So we already know this, but it's really interesting to think about why. Why do we have these two sources and how do they interact the way that they do? And to understand that, I think it might be useful if we have a look at this guy. So this is actually a guy by the name of Charles de Montesquieu. He was a French philosopher. In 1748, he formulated the doctrine of separation of powers in a book called The Spirit of Law. Now, you don't need to remember those facts, but it's just interesting. So it comes from the French in this book, The Spirit of Laws. And what did the separation of powers actually say? All the separation of powers is saying is that we need to separate out the responsibility and power from those who make the law to those who administer the law, from those who actually interpret or apply the law in judgments. And we can see that on this slide, which comes from our book. Here we have government having three arms: the legislature, the executive, and the judiciary. And each of those arms has a different role. The legislature or parliament makes laws. The executive or the government, the departments, etc., and the cabinet ministers, they administer the law. And the judiciary actually interprets the law. So here we have, not only at a federal level, but also at a state level, the separation of powers in terms of parliaments, the Prime Minister and ministers who form cabinet. So you've got to understand those terminologies as part of the course. And they're responsible for the day-to-day decision making that occurs, as opposed to the legislature who actually make the laws. And then we have the judicial power who interprets and applies those laws through the doctrine of precedent. So what we have here is the idea that the executive and judiciary should, as far as possible, should be separate. So the people who are enacting the law on a daily basis shouldn't be judging whether the law is right. So the same person shouldn't be part of the three arms of government, and in a strict separation of powers, there shouldn't be anyone across the arms of the government that we're looking at. One arm shouldn't control or interfere with the other. You'll often see this in the press when judges are coming out talking about the independence of the judiciary, where it's really absolutely critical to have this independence. And it's often why judges don't respond to criticism, and why politicians are especially criticised if they criticise the judiciary. Because what they're doing is they're interfering in another arm of government, and it breaches the idea of the separation of powers, one of the fundamental ideas of democracy and of treating people fairly that we have, particularly for those in the Anglo and the Western world. Okay, so one arm should not exercise the function of another. So that means that someone like the executive shouldn't execute judicial power. So they shouldn't be judging whether or not someone's breached a law. They should take that to another body, which would be in the judicial arm of government. So have a think about this. Why do you think the separation of powers is important? Is there a true separation of powers in Australia? As you think about this little slide, which isn't in the slide pack, might help you think about, does Australia have a true separation of powers? And this is at the federal level. You can see we've got Parliament, we've got Cabinet, and we've got the judiciary. Do we really have a true separation of powers in the strict sense of the word? Something from a very current debate: do we actually have a Bill of Rights? Let you think about those questions, and you might ask me in class if you can't figure it out. Okay, so as well as having the idea of separation of powers, which is fundamental, the second idea in this little podcast is the idea that we have different legal systems around the world. So the law is operating within a legal system, and these legal systems differ from country and country. Broadly, there's two key categories: a civil law system and a common law system. Now, this is way confusing, right? Because we've been talking about criminal law versus civil law. This is a different use of terms, okay? It's about the difference between a civil law system in a country and the common law system in Australia and in a lot of those countries with British heritage. So what's the main difference? Well, the main difference is that the civil law system has as its primary source of power the legislation. That's where the law actually comes from codes, statutes, and constitution. they don't generally record cases and they don't have precedent like we have. Courts use quite a different system too. It's inquisitorial. What does that mean? The judge kind of runs it asking questions to find out what the truth is. That's not actually how things happen in the Australian system and in a common law system. In fact, it's quite the opposite. The judge is meant to be impartial. We have what's called an adversarial system, and that means the two sides have people who represent them, and they argue their case, which then gets judged. So the judge isn't really there trying to get to the truth in an inquisitorial sense. The judge is trying to balance the arguments and making sure that the procedure is being run correctly. So they're quite different systems in how they're applied in that sense. It's not just about this difference between legislation versus case law. That is an important difference. But the whole style of the law is quite different. And that makes it really hard. If you've come from a civil law country, understanding this is a fundamental difference. And the same for us in a common law country. When you go to a different country that runs an inquisitorial system, it becomes, that isn't fair. The judge is doing this, seems to be taking sides. No. Entirely different system. Something really to get your head around. And what we see is what system people have tends to follow history. So the civil system developed from Roman law, and it was really consolidated through the French and Bonaparte through Europe. So most of continental Europe is a civil law system. And then any countries that were originally colonised by the continental European countries tend to have a civil law system. That's just the way, the timing of when things happened. In contrast, the common law countries tend to come from Britain. And where Britain had the British Empire, you'll find common law systems through a lot of that area. So, I think I've been through most of the points here about the common law system. It's based on the British system. We have case law as well as the legislation, and the judiciary is more powerful and influential because they interpret the law as well, and we use this adversarial system. So, common law and civil law can have these different interpretations depending upon the context we're talking. If we're talking about criminal law versus civil law, we're actually talking about the difference between criminal law and all other law between people. If we're talking about the difference between a civil law system and the common law system, we're talking about different systems in different countries. Really important to understand that difference. And in fact, a couple of slides that might help you with this. So we can see in this slide that there are different sources, different kinds of law. Now, I haven't talked about Sino-Soviet law, but in essence, communism through China and the Soviet Union had quite a different system of law to the civil law, so that was a major source of law. We have the common law, which we've talked about, the civil law, which we've talked about through continental Europe, and there also are other systems of law, often based upon religion. So some nation states have religion as the key source of their law. We're going to concentrate on the middle two for this course, and you can see that underneath the idea of the common law in our system, we can then split all of our common law into criminal law and civil law. And we can also split the idea of our common law system into the idea of legislation and statute, or common law as the idea of case law. So it gets rather confusing. And if I was going to confuse you even more, I'd show you this slide, which says that we have common law as a system, common law as case law, and then there's a particular kind of law, which you can see here, that we have all these different kinds of law, administrative law, admiralty, probate, equity, family law. There's also a type of common law at that sense 3. So, understanding common law can be a system, common law can mean case law, common law can mean a particular kind of law. Civil law can mean a civil law system, like in continental Europe, and an inquisitorial style of law, and it can also mean non-criminal law.